very well-reasoned. She's certainly obviously spent a lot of time reviewing the evidence and the legal argument before she came to her decision.
Are you disappointed in the outcome?
It's not about me. It's about my client and what's in store for him in the future.
Is your client disappointed in the outcome?
I haven't had a chance to talk to him directly about it. We thought that we raised some interesting points, and I think that the judge agreed with us that there were forces in Mr. McLaughlin's life that to some extent shaped him. But at the end of the day, I think she was of the view that he was fundamentally responsible for his own behavior.
A dangerous offender designation is quite extreme. Is the public safer with this designation, do you think?
Well, that's a question for the public to answer and for Parliament to respond to. So I can't really offer a comment on that. It's the law of the land in Canada.
Did you have a lot to work with against this request? You know, you look at he's 45, he's spent 20 years behind bars in total, more than 70 convictions, you know, the latest crime in 2009. How do you kind of evaluate that?
Well, we tried to some extent humanize Mr. McLaughlin, to show the judge that there were things that had happened to him, that he wasn't responsible for. I think to some extent we succeeded in doing that. But at the end of the day, the offenses to which he pled guilty and accepted responsibility for were pretty extreme, and he had a very unenviable track record.
What kind of things, if you can tell us, what kind of things did you try to present that humanized him?
Well, the judge alluded to this in her judgment. One was the matter arising out of Calgary, the fact that he was placed into segregation after becoming a Crown witness on a homicide, that he, at points in time, succeeded quite admirably in rehabilitative courses and this sort of thing. That's part of the job. It's a human experience, this whole thing, and I think that Judge Pomerantz was careful not to look at Mr. McLaughlin just as a person who had a criminal record with a certain amount of convictions, and I think that she recognized that there were things that had happened in his life that shaped him, and that's one thing that we tried to get across.
You've probably gotten to know him in defending him in this dangerous offender application and the defense in the trial. What's he like?
Really not comfortable answering that question. He has generally been a good client in that he's respectful of me and my office, and I think generally speaking to the rest of the players in the criminal justice system. But you have to bear in mind, this is a very, very highly charged emotional business that we are in, both defense, Crown, and the judge, and a lot of times it's extremely difficult to keep one's composure.
Where will he serve his sentence?
That I'm not entirely sure. He's going to be remanded, probably back into the federal system, and he is eligible to apply for parole, and so his fate will be in the hands of the parole board. And one of the, when you have an indeterminate sentence, the thinking is, well, the key's been thrown away of the lock to the cell door, and that's not the case. Our system of criminal law in Canada does not contemplate that people are locked up for the rest of their lives. They do have parole eligibility, and it's a very complicated system, but there still is eligibility for parole for any offender under Canadian law.